Hi, I'm Anna Denton-Jones of Refreshing Law, and this is the last in a series of short videos talking about shared parental leave. In earlier sessions, we've looked at eligibility, we've looked at the mechanics of how the whole system's going to work, and various issues that will have arisen throughout somebody taking shared parental leave, including how somebody's going to be paid. In this last video, I want to talk about returning to work. You need to very much think of this in the same terms as you would for somebody returning to work from maternity leave. So if somebody has taken less than 26 weeks in total off, whether they're the mother or the father, then they are going to be entitled to return to work to their old job. And if they've taken that leave in discontinuous blocks, which we've seen that they are able to do, then it's to return to the job that they were doing at the point that they took the first period of leave. If somebody has taken more than 26 weeks, then the employer's got a bit more flexibility. If it's no longer reasonably practicable for somebody to return to that job that they were doing before they went on the leave, perhaps because things have changed over the lengthy period that they've been off, then you are looking at bringing them back into a job that is suitable for them to do, and in terms of terms and conditions, location, etc., is no less favourable to them than the job that they had before. One of the things, of course, that can arise in tandem with leave is how you deal with holiday. You're going to need to think about whether you're going to ask somebody to take the holiday that they've accrued during a period of shared parental leave, perhaps at the end of the leave period before returning to work, so that if you've got cover arrangements in place, that perhaps they just continue for a short while whilst you use up that holiday. Another alternative is to obviously agree that they take some of that holiday before they go on leave, and I know different employers have different practices in that regard, but of course the person is going to accrue holiday throughout the period of shared parental leave. The other issue that may arise, of course, is that things have changed dramatically, perhaps whilst the person's been away, and we end up in a redundancy situation. Now, obviously, if we were to simply select somebody for redundancy because they've been on shared parental leave, then we would be into treating them detrimentally and possibly automatically unfair dismissal territory. But let's say somebody's at risk of redundancy, perhaps a whole department shutting down. What are our obligations to that person who's been on shared parental leave as compared to an ordinary employee? Well, you want to think very much in terms of Regulation 10 of the 1999 regulations, in terms of the extra leg up that it gives to women who are on maternity leave, in that they're entitled to any suitable alternative employment that's available, and the same rule will apply here. Somebody who's been on shared parental leave, if they're at risk of redundancy, they get preferential treatment then when it comes to alternatives that may be available. But it's interesting, there's case law that suggests that suitable alternative role needs to be in the same location. There was a case recently where somebody had been employed in London and she was arguing she should have been offered a role in Cheltenham, and without wanting to upset anybody who's from Cheltenham, the court said that that's such a substantial difference that it wouldn't count as suitable alternative employment. That's not to say you wouldn't, of course, discuss it with the employee, because they might well relish the opportunity to relocate, and if you've got a job there and they could potentially fill it for you, then you may well want to look at it, but you're not going to be forced by the law to do so. The job needs to be a work of a suitable kind, is the wording that's used in the legislation. There was a case of a primary school teacher who was teaching a particular age group before she went on maternity leave, and she argued when she came back and there was a redundancy situation that meant she had the right to work with that particular age group again in the future. The court looked at her contract of employment, which had a flexibility provision in it. Essentially, she was employed as a primary school teacher, which could mean teaching any age group. So in that scenario, she didn't have the right to dictate to the school which age group she was going to teach when she returned to work. It was for the employer to find her a job teaching in a primary school class. The fact that it was a slightly different age group was perfectly acceptable. If any of you have got any questions on today's session, please do email me, adenton@refreshinglawltd, all one word, .co.uk, and I look forward to receiving all your questions in relation to shared parental leave. If anybody is looking for help drafting their policy on this, then please do let me know. There are special rates on offer at the moment. Cheers, thank you very much.